From the Money Desk, good morning to you. I'm Sindy Mabe. South Africa has one of the highest unemployment rates in the world, and this is the primary reason the Competition Commission must consider the effect on employment when evaluating a proposed merger. Reece May, Senior Associate in Competition Law Practice at Clive Decker Hofmeyer, joins us now. And good morning to you, Reece, and thank you so much for your time. Just look at the distinction between acquisitions and mergers and how the Section 189 is applied in these two processes.
Good morning, Cindy. Thanks so much for having me. So maybe before we get there, competition law in South Africa plays a very unique role as far as mergers are concerned. And for all the viewers out there, a merger very simplistically is where one company acquires control or buys, for a better term, another. And many people don't know, but you first need to, when you're contemplating a merger, you first have to go to the competition authorities to get approval. And the whole analysis really centers around the deal, on the one side, not adversely affecting consumers. So in other words, that the deal will result in adverse price consequences. And then on the other side, which is the main sort of topic for today's debate, is whether it'll affect the public interest, as the Competition Act calls it. And that's aspects such as employment and the spread of ownership in particular.
And we've particularly seen this, I beg your pardon, we've seen this play out in the mining sector as well, where there's certain expectation not only from the unions and also how important communication is when these mergers occur to avoid any further conflict.
Yeah, so that's right. So generally the process really entails that because a competition commission is mandated to investigate employment, they contact unions and employees alike. And if they have any concerns that the potential merger, so the new acquirer, will cut any jobs, that is quite closely interrogated by the Competition Commission, and very often results in conditions being imposed on the parties to ensure that jobs are ultimately protected for the public good.
All right, so unpack those conditions, as you were saying, that the Competition Commission can impose certain restrictions, especially when it comes to retrenchments during mergers, but it's still the company's prerogative, though, to exercise that streamlining of their operations.
Yeah, 100%. I think it is definitely a balance between, competition and efficiency, as well as protecting the public interest. Very often the Commission, if they have any doubts as to whether there will be retrenchments in the future, they require the parties to undergo a 3-year moratorium on merger-related retrenchments. So that's where the compromise really comes in, that any mergers must really be related to, the new acquirer, and not for other reasons, operational reasons, if the business isn't doing well, etc. So.
Yeah, but how does the Competition Commission then enforce the law, especially if companies were to circumvent the merger restrictions, so to speak, when it comes to retrenchments, and maybe cover it up as operational necessities?
Yeah, that's a very good question, something we deal with quite often. So what generally happens is that when you get your merger approval, it'll either be unconditional or on this condition, like we said. And if aggrieved employees do feel that it was, before the acquirer that they got the various retrenchments, then the Commission actually investigates, and they have the powers to, even if the parties misled the Commission during the investigation, to nullify the merger entirely. So the parties take this very seriously, and when the investigation happens, they provide a lot of documentary evidence to show, the real reason for retrenchments, which in the most cases is for operational reasons and not for, as a result of the merger, for efficiency.
Yeah, and in your practice, which sectors are primarily more keen to mergers or even acquisitions, or does it cut across the spectrum?
Yeah, our practice deals with mergers across the board. But we find these issues really, come to the fore in industries that is very labor intensive, such as fishing and, like you rightly said, mining. That's really where it is a big sort of focus on this, with a large employee base. And I think the skepticism from the Commission is that with so many employees, you might be able to, hide any transgressions. So yeah, that's where the skepticism comes from. But we always advise our clients to just play your cards, open, and try and help the commission as best as you can.
Yeah, and where parties might conceal certain information, particularly if they want to avoid any penalties from the Competition Commission, how much weight does the Competition Commission have, not only to monitor, to evaluate, but also to supervise, to make sure that jobs are protected during the merger process?
So when conditions are imposed, they generally have a monitoring obligation. So the parties are obliged for a certain period, normally it's about 3 years, to report back to the commission on a regular basis, on affidavit most of the time, to say, that no retrenchments have taken place that are merger related. And also they distribute the conditions to all the employees, and especially to trade unions, if there are any. And then they'll ensure that sort of condition gets, really monitored and enforced.
Yeah, and the SMMEs, particularly being the cornerstone of employment and the nerve center for the economy as well. When it comes to mergers, are we likely to see more in terms of established businesses that would practice mergers or acquisitions, or is it also small enterprises that you've observed embarking on an acquisition and a merger?
Yeah, so we've seen quite a lot in the sort of private equity space of smaller businesses getting, a lot of traction, a lot of interest from these private equity guys. But the merger thresholds operate. So mergers are only notifiable if companies are of certain economic significance. So if the companies are really small, then there's no mandatory sort of obligation to notify the commission. So some of those might go under the radar for now until the commission sort of adjusts its thresholds.
Yeah, and your expectations when it comes to the GNU and particularly the Department of Trade of Industry, whether there might be any reforms in this regard that could impact companies that want to either expand or even to amalgamate?
Yeah, so to be honest, there's been a lot of debate in the industry as to, what the new minister will do going forward. But in our experience under Mr. Patel in the last few years, the DTIC has played a very active role in merger investigations, trying to increase, BEE ownership and especially to protect jobs. So we are expecting much of the same and expecting some fruitful sort of engagements with the DTIC. So yeah, I'm sure that policy will come through strong in the next year or two.
All right, thank you so much for your time on this Friday morning. That's Reece May, Senior Associate in Competition Law Practice at Clive Decker Hofmeyer. And coming up next, Morana Mutupi